Mic test, 1, 2. This is a mic test. 1, 2, 1, 2, 1, 2. Mic test. Good morning. This is a mic test. Yes, we see the captions. Thank you. Second mic check. This is a mic check. 1 2 1 2 1 2. Captioning is good. Thanks. This is another mic test. Mic test 1 2 3 1 2 3 1 2 3.
Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, September 27th, 2023. The time's 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Janecka, as well as our General Counsel, and I am John Neerman. For those who are joining us virtually, I'll ask that you please keep your microphones muted while you're not speaking. And for those who will make presentations, I'd like to ask you to please wait to begin your presentation until our General Counsel or I have asked you to begin speaking. On items where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you would like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to speak to, and we will do our best to accommodate that request. With that, I'd like to thank everybody for being present today, and Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the application by the City of Lubbock for water use permit number 5921. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So, colleagues, as you know, requests for contested case hearings on water use permits are governed by Chapter 55 of our rules. We're required to identify persons who are entitled to a hearing. We do not need to refer specific issues to SOA. Considering the factors at Section 50.256, I agree with the Executive Director and OPIC that R.E. Janes Gravel Company, Clark Wood Jr., Justin Damron, Michael Damron, and John O. Long are entitled to a hearing by virtue of their water right or their riparian interest. Consistent with the Executive Director's recommendation, I would add the Brazos River Authority to that list, and consistent with OPIC's recommendation, I would add John and Marianne Lovelace to the list. I would deny the remaining requests. Ms. Carmody does not have a permitted or riparian right, nor will her property be impacted by the proposed reservoir. The two counties each fail to articulate a personal justiciable interest in the permit, and indeed, this project is located in a different county. As for the Garza-Kent-Brazos River Landowners Coalition, I believe they lack standing because that organization failed to identify a member who would have standing in his or her own right. So that's where I land on this item. Commissioner Lindley, what are your thoughts?
I'm in agreement on all the parties, and I know it's a lot of parties, but I would still recommend referring it to ADR, just because this permit's it's been in-house a very long time, and if there's any way to work things out before the longer process of a hearing, I think we should give it a shot. So I would include that in my motion, but I'm in agreement otherwise.
Great.
I'm in agreement with your finding as to the parties.
Great. I think we're ready for a motion.
I'll give it a shot. I would move that we grant the hearing request of the Brazos River Authority, Justin Damron, Michael Damron, R.E. Janes Gravel, John O. Long, John and Marianne Lovelace, and Clark Wood Jr., that we deny the hearing, all the remaining hearing requests, that we refer the matter to SOA for a contested case hearing on the application, and that we also refer the matter to the Commission's alternative dispute resolution program to run concurrently with SOA's scheduling process.
I second the motion.
The motion has been made and seconded. All those in favor say aye. Aye. The motion carries. Ms. Smith, please call the next item.
Item number 2 is the application by FM 665 for new TIPD's permit number WQ00161-33001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Colleagues, the sole requester on this item failed to identify any issues in his hearing request, so I would deny the request.
I agree.
Likewise. Any other discussion?
I think we're ready for a motion.
I move that we deny Christopher Phelan's hearing request adopt the executive director's response to comment and issue the draft permit as recommended by the executive director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the application by Gildan Blair Blackburn and Timothy Edward Carter for new TIPD's permit number WQ 00161-24001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, we have a single item on this request as well, but in my view, this one actually meets all of the procedural and substantive requirements to be entitled to a contested case. And while the physical address that was included in the request may have caused some confusion, I believe the narrative description as well as the adjacent landowner's map demonstrates the requester's proximity, and combined with other elements, in my view, this is sufficient to demonstrate effectiveness. As for the issues, I would refer the following: whether the draft permit is adequately protective of water quality, and that includes surface and groundwater as well as aquatic livestock and wildlife; whether it is protective of the health of the requesters and other individuals who reside near the proposed facility and discharge route; whether it adequately addresses nuisance odors; whether the commission should deny or alter the terms of the permit based on need, as we understand that policy under Texas Water Code Section 26.0282; whether the anti-degradation review meets all applicable requirements; and whether the draft permit includes adequate nutrient limits. I would include an ADR referral on this one, and I think that the SOA referral obviates their request for reconsideration.
I'm in agreement. I've got a motion then, I'll give a shot. I move that we grant the hearing requests of FM 1189 LLC, Bartlett Ranch Brock LLC, Series A, EGHB Investments LLC, and Series A 1189 Storage LLC. That we deny the request for reconsideration, and that we refer the application to SOA for a contested case hearing on the following 5 issues. Issue 1, whether the draft permit's adequately protective of water quality, including the protection of surface water, groundwater, aquatic life, livestock, and wildlife, in accordance with applicable regulations, including the Texas Surface Water Quality Standards. Number 2, whether the draft permit's protective of the health of the requesters, their families, and other individuals who reside in the immediate vicinity of the proposed facility in the discharge route. Number 3, whether the draft permit adequately protects against nuisance odors in accordance with 30 Tax Section 309.13E. 4, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Quality, Texas Water Code, Section 26.0282. And lastly, issue 5, whether the anti-degradation review complies with applicable regulations and the draft permit includes adequate nutrient limits. And that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the application by Smiling Mallard Development LTD for new TIPD's permit number WQ 00160770001. The parties have been notified that the commissioners will take oral argument, or will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Colleagues, we have several hearing requests on this item, so for the benefit of those who are not familiar with our process, Chapter 55 of our rules provides a two-part analysis for considering requests for contested cases on TIPD's applications. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case, and assuming at least one requester meets those requirements, we then consider which issues to refer for hearing. So part one is about who gets a hearing, and part two is about which issues are referred. Requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. And colleagues, of the 9 requests on this item, I would grant just one. I believe that Herb Flanagan has met the procedural and substantive requirements to be entitled to a hearing, and that he has preserved the issue of concern about nuisance odors. And while this permit authorizes a relatively modest volume of discharge, and it's pretty typical of treated domestic wastewater, Mr. Flanagan's address is about 1/10 of a mile from the proposed facility, so there's little question in my mind that he may be affected in a manner different from the general public. So in my view, he is in. I would deny the request of the remaining requesters because I don't see that any of them adequately described a personal justiciable interest. Again, I would refer him just on the sole nuisance issue, and I would include an ADR referral. There are also some requests for reconsideration on this item, but I don't see that they contained any new information that was not already available to the executive director, so I would deny those. And I think that may dispose of all the issues.
I'm in agreement, yeah.
Likewise.
I think we're ready for a motion.
I move that we grant the hearing request of Herb Flanagan, deny the remaining hearing requests and requests for reconsideration, that we refer the application to SOA for a contested case hearing on the following issue: whether the draft permit adequately protects against nuisance odors in accordance with 30 Texas Administrative Code Section 309.13E. I further move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the consideration for adoption of the renewal with amendment of the state-only general permit number WQG 200000. The executive director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Shannon Gibson with the Water Quality Division. With me today is Bobby Salil with the Environmental Law Division. Staff requests adoption of a renewal with amendments of state-only general permit number WQG 200000, which authorizes the disposal of wastewater generated from livestock manure composting operations and processes by evaporation or beneficial use by irrigation adjacent to water in the state. The proposed permit will replace the current general permit, which expires on November 10th, 2023. The state-only permit was not subject to an EPA review. However, public notice of the draft permit was published in the Houston Chronicle newspaper on March 31st, 2023, and in the Texas Register on April 7th, 2023. No public comments were received during the public comment period. Staff recommends adoption of this general permit. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with the Texas Register requirements. Thank you, and we're available for any questions.
Thank you, Ms. Gibson. I have none. Any questions, colleagues? Ms. Smith, has anybody signed in to speak?
No one is signed in on this item.
Mr. Arthur, what do you think?
Good morning, Chairman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC has no objection to the renewal with amendments of the manure compost general permit.
Thank you, colleagues. Neither do I. This is a renewal with some clarifying amendments. It was addressed in the Water Quality Advisory Work Group, as we heard, put out for notice and comment. No comments were received. I'm ready to move forward.
I am too. With that, I would move that we adopt the renewal with amendments to general permit number WQG2000000 as recommended by the executive director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 6 is the consideration of the Office of Public Interest Counsel's 2023 annual report, and the Public Interest Counsel is here to present the item.
Mr. Arthur, good morning again.
Good morning again. Texas Water Code Section 5.2725 requires that OPIC annually report to the Commission and provide 1, an evaluation of the office's performance in representing the public interest in the preceding year, 2, an assessment of the budget needs of the office, including the need to contract for outside expertise, and 3, any recommended legislative or regulatory changes. The written report before you is intended to satisfy this statutory requirement for fiscal year 2023. First, the report evaluates OPIC's representation of the public interest by using previously identified performance measures in 4 types of proceedings: environmental, district, rulemaking, and enforcement. For each proceeding type, these performance measures show 100% participation by OPIC. Second, the report assesses OPIC's budget needs, including a discussion of possible outside technical support. Finally, Attachment 1 to the report contains a recommended regulatory change. Specifically, OPIC recommends that 30 TAC Sections 80.105 and 80.252 be amended to allow 30 working days rather than 60 calendar days from the close of a contested case hearing record until issuance of the proposal for decision. We believe this reallocation of the available time period would serve the public interest by allowing parties more time to develop the evidentiary record and present arguments in support of their respective positions. To conclude, OPIC appreciates this opportunity to review its work and recommits to its statutory directive to protect the public interest. Thank you, and I'm happy to answer questions.
Thank you, Mr. Arthur. I don't have any at this point. Colleagues, any questions? Okay, Ms. Smith, is anybody signed in to speak?
Yes, we have Mr. Vasu Bahara.
Good morning, sir. I'll ask you to check that microphone, make sure you have a green light, and then when you're ready, just state your name for the record, and the floor is yours.
Commissioners, Council, thank you for your time. My name is Vasu Bahara. I'm the Deputy Chief Administrative Law Judge for the State Office of Administrative Hearings. I'm also joined with our General Counsel, Shane Linkus, and he's also here to answer any questions that you might have. I was here to speak about what was referenced in Section 3A of OPIC's outside technical support section. There was a reference to a possible proposed rule making process regarding the reducing the 60-day writing window that SOA has. And I really wanted to just come here to voice a few concerns and highlight a few issues for the commission in that regard. The 60 days derives from the Administrative Procedure Act, and that is basically what charges the administrative law judges to issue a proposal or a decision within 60 days of the record close. And so that starts our timeline. And so I wanted to, in that context, really wanted to talk about why that time frame is vitally important for SOA as an agency. As you all know, you've already referred a couple matters to SOA today, but SOA, as I think OPIC referenced, that they handle about 607, they participate in about 677 proceedings, which is quite a lot. SOA over the fiscal year typically averages around 25,000 hearings a year. And so those can include, obviously, the SB 709 matters that are referred to us, enforcement matters with TCEQ. But we also have driver's license suspensions, occupational licenses. That includes doctors, chiropractic, nurses, electricians, a whole slew of different types of occupational licenses. We have tax matters. We set utility rate cases. So all those matters come into play because we have a limited number of assignments for judges that can handle those cases. And we have all those cases require a written decision, thoroughly reasoned, well-reasoned decision, just like the ones for under SB 709. And so in part of that requires a review of the entire record. Obviously, the administrative record, which in these particular matters or other matters can be thousands of pages, pre-file testimony, reviewing the admitted exhibits, and then we go through a writing process. And the writing process includes, obviously, the drafting of the decision, which you're contemporaneously doing those with all those other types of cases, along with, after we're finished with the first draft, we will submit that for what's called a first review process. That goes to another administrative law judge for a very thorough, substantive, and procedural review. Typically what you would think in the law review style review. So that's a very substantive review. We get edits back. Then we go through a second review. And a second review, another ALJ reviews that matter. And so all of that comes into play within that 60-day window. Finally, there's a legal staff review before filing the matter. And so we're running up against a great timeline. And so that's why I wanted to make sure we talked about this review process. In that context, we have about 25 administrative law judges in Austin who are trained and have the capacity to handle cases under SB 709 typically. And they're also handling all those other types of complex matters that we discussed. The TCEQ, the SB 709 matters are typically some of our most complex cases that we get. As y'all know, multiple parties, varying interests, and voluminous records. And sometimes there are more than one or two judges on those cases, and they take anywhere from a few days to weeks. Just like our other cases, those can take a few hours, or those can also take several weeks. And so in that context, I really wanted to make sure why we kind of described why the process of reducing our window would really have a significant impact on our agency. We definitely try our best to issue these decisions as quick as we can, but really the goal is to provide the commission with the most well-reasoned recommendation that we can make for y'all. And if the timeline is crunched for that, that really puts us in a little bit of a jam. So that was basically the gist of why we came here to voice that, to highlight those concerns, and happy to answer any additional questions. Like I said, have our general counsel here to also answer any questions for you.
Thank you, sir. Appreciate the comments. I don't have any questions. Colleagues, any questions?
No, thanks for coming out today.
Thank you.
Thank you. All right. Anybody else? Any other interested persons signed in to speak?
No, I think we're ready for the ED.
Okay. Let's hear from the Executive Director's Office then.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I'm Charmaine Backens with the Environmental Law Division. With me are Elizabeth Cifuentes Cope with our Sunset Review Team and Steve Talcott with our General Law Division, representing the Executive Director. Executive Director staff have reviewed the annual report and appreciate the information provided. As part of its annual report, the Office of Public Interest Counsel, or OPIC, discussed the use of outside technical support, describing factors that make it difficult for OPIC to retain technical consulting services. OPIC stated that the primary obstacle preventing OPIC from more often obtaining outside expertise is the contested case hearing timeline established by Senate Bill 709, which requires an administrative law judge to issue a proposal for decision no later than 180 days after the preliminary hearing. According to the report, that time is shortened by the State Office of Administrative Hearings reserving 60 of the 180 days for the administrative law judge to prepare the proposal for decision. In its annual report, OPIC proposed amending 30 Texas Administrative Code sections 80.105 and 80.252 to require an administrative law judge to issue the proposal for decision no later than the 30th day after the judge closes the hearing record. If the administrative law judge is unable to file the proposal for decision within the 30 days, the judge must request an extension from the commission by filing a request with the chief clerk. The proposed amendments may go beyond what is allowed in statute. Texas Government Code Section 2003.047 governs hearings for TCEQ. Subsection E states that the administrative law judge may extend the deadline to complete the proceeding and provide the proposal for decision, either by agreement of the parties with the approval of the administrative law judge, or if the judge determines that failure to extend the deadline would unduly deprive a party of due process or another constitutional right. Furthermore, procedurally, once a matter is referred to the State Office of Administrative Hearings, the State Office of Administrative Hearings has jurisdiction over the case, and it is not clear how the administrative law judge would request an extension. The executive director recognizes and appreciates OPIC's representation of the public interest. We're available for any questions. Thank you.
Thank you. I have none. Colleagues, any questions? All right. Well, Mr. Arthur, appreciate the report. Let me begin just with a word of gratitude about the great work that your team does. I have come to rely on it at every agenda and really appreciate that. As for the report, it's your performance against the OPIC performance measures is exemplary. That's fantastic. I appreciate your attention to the Sunset Recommendation 4.1 relating to contracting with experts. And I think before I get into the recommended rule, I might hand it over to my colleagues to see if they have any comments about the report other than the rulemaking, then we can get down to that discussion.
I really don't. I would echo that. You know, y'all carry a big load in your tiny little office, so appreciate everything y'all do with the resources you have.
I echo all those positive comments and add a challenge to ask a question about those goals, the reported progress, where OPIC is making exemplary efforts to represent the public in literally every case that goes before SOA. It unfortunately, I think, just presents a liability for SOA. Inevitably, something will happen. Some matter will get discussed, and I want to acknowledge and express my thanks for our colleagues from the State Office of Administrative Hearings coming and speaking up for their agency's complexity and process and the demands that are placed on those 25 to 30 professional individuals in Austin and across the state. But where OPIC's engagement in this very complex process is, I think it's a really stilted report to us and to the public, where you've done it again. You've made it to every hearing. I wonder, is there an opportunity to, and I don't think there's an answer to this right now. I'm not sure where. I'm challenging you and inviting question from you as much as I am from interested members of the public who are out there and may have insights from their vantage point, which is not dominated as ours is by the process that we are trying to shepherd responsibly and fairly for the public, as they have these contested, inherently combative. These are matters that people are fighting over, arguing over. So to that end, I just want to compliment SOA on their or OPIC on your great efforts in representing the public's view at all of our matters. I wonder what you may need from us to be able to more meaningfully report OPIC's engagement. And I want to capture the victories that OPIC has achieved in my watch that I've seen, where your engagement from your office has really specifically enhanced the work product that came back to us from the administrative law judge, where they had a much more complete administrative record to give an enduring regulatory document that works to inform our process, but for other related matters. It's an important thing for the state of Texas and for the public to just have an understanding of how our regulatory process works. So I'll stop there, but I appreciate and want to compliment OPIC and just, my kingdom for a meaningful goal, a meaningful reporting measure. I'm not sure exactly how to improve it, but thank you.
Thank you, Commissioner. Colleagues, turning to the rulemaking itself, I think there's, since we have a finite period in which to hear these cases, I should say SOA, and offer a proposal for decision that's set by statute, there's an inherent tension between the amount of time that the parties need in order to present their case and the amount of time that the ALJs need to draft a high-quality proposal for decision. And I very much appreciate the concern. It's very real, legitimate. I do, however, in the end, think that SOA is in a better position to balance that, to balance the parties' needs on the one hand, to presenting their case and protecting the parties' due process rights, and on the other hand, to allow them enough time to draft a high-quality PFD. So I think I would decline to undertake that rulemaking and leave that time allocation, the calendaring to SOA. And colleagues, if it's all right with you, I'd like to offer a motion on that that we could discuss on the other side.
Works for me.
Okay. It's basically repeating what I just said. Colleagues, I move that we decline to initiate OPIC's recommended rule changing to limit the time that SOA administrative law judges may use to write their proposals for decision and proposed orders, because SOA is generally in a better position to evaluate and manage the competing scheduling interest involved in TCEQ cases, including the length of time necessary to draft their PFDs and proposed orders, and deciding when an extension to preserve the rights of the parties may be warranted. So that is my motion, and I read it quickly, so I'm willing to reread it, but I'm eager to hear your thoughts.
Yeah, I will. I don't have a whole lot of thoughts. I'm in agreement. You know, I think it was right, and I think it was appropriate for y'all to bring it up in the report. I think, you know, this is where you need to do it and to raise the issue. I personally just kind of have a feeling about, you know, how I see it is SOA works for us in the sense that they hold a hearing for us, but they don't work for us. And so I have a little bit of a hard time dictating how they should operate and that kind of thing, because I just kind of look at it as if a different state agency did that to us, I would not take that well. So again, I think this is the appropriate place to bring it up, but I would second the motion, and I don't want to do it yet. I'll let you speak, but I'll stop there.
I'm fully in agreement as well, and I'll let you second it.
Then I second your motion.
All right. Colleagues, in that case, the motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you, Mr. Arthur, again. Appreciate the report. And Ms. Smith, when you're ready, I'll ask you to please call the next items.
That brings us to our enforcement docket, which are items 7 through 21, and the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell with the Enforcement Division, and with me today are Michael Parrish, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before you are items 7 through 21. The total assessed administrative penalties are $191,211, with $9,492 deferred, $17,850 applied towards supplemental environmental projects, and $163,869 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Any questions, colleagues? Seeing none. Ms. Smith, is anybody signed in to speak?
On items 10 and 11, we had several individuals who signed in but indicated that they don't wish to address the commission.
Thank you. And what does OPIC think?
OPIC supports adoption of these enforcement orders as presented by ED staff.
Thank you. Colleagues, I do as well.
I agree.
I move that we adopt items 7 through 21 as recommended today by the Executive Director.
A second.
Motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 22 is our enforcement report, our monthly enforcement report, and the ED staff is here to present this item too.
Good morning again.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Michael Parrish of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2023 through July. There were 899 effective administrative orders issued, and of those, 122 contained supplemental environmental projects. These orders assessed a total of $12,349,883 in penalties, with a payable amount of $7,384,380. $3,230,040 are to be paid towards supplemental environmental projects. 13,076 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,868 enforcement action referrals have been received. There are 2,323 pending administrative orders, with 1,227 cases that are on the backlog as it's currently defined. Currently, 5% of our total pending and proposed caseload is older than 2 years. 179 cases are pending at the Attorney General's office for representation in district court, and 15 judgments have been issued. 2,139 cases are being tracked for compliance. We've included for review a summary of OCE investigative activities for fiscal years 2021, 22, and 23. We are available to answer any questions you may have.
Thank you, Ms. Cordell. Not a question, just an observation. I just wanted to express concern about the backlog of cases, and it's no secret that we are in the middle of a staffing problem. It appears to be getting a little bit better. We're hiring more than we are losing, but I attribute the much higher backlog number of cases that we have compared to a few years ago to that staffing issue. I guess if I were to find a hopeful note, we're not digging the hole as quickly as we were before, but we're still going deeper into the hole. And in my view, that is purely a staffing concern. So you may respond to that if you want, but it's just my observation. Colleagues, did you have any questions or comments?
Thank you for raising that point. That was exactly, that always is my thought as I'm reviewing these reports, and I appreciate how they represent, I think, exemplary progress and effort that the Enforcement Division and our agency's compliance staff are doing, given their constraints.
Thank you, Ms. Cordell. Ms. Smith, has anybody signed in to speak on this item?
No one has signed in.
Mr. Arthur?
OPIC has no comment except to say that, as always, we appreciate the report.
Thank you. No action is necessary on this item. So thank you again, Ms. Cordell, and thanks to your team for their outstanding work, and Ms. Smith. I think item 23 is going to involve quite a bit of discussion. Why don't we jump ahead and take items 24 through 28 and then come back to item 23.
Items 24 through 28 are consideration of the quadrennial rule reviews for 30 Texas Administrative Code Chapters 20, 25, 33, 90, and 116. The Executive Director's staff is here to present these matters.
Good morning, Ms. Rico.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Gwen Rico with the General Law Division. Pending before you are items 24 through 28, the adopted rule reviews of 30 Texas Administrative Code Chapter 20, Rulemaking, Chapter 25, Environmental Testing, Laboratory Accreditation and Certification, Chapter 33, Consolidated Permit Processing, Chapter 90, Innovative Programs, and Chapter 116, Control of Air Pollution by Permits for New Construction or Modification. As required by Texas Government Code Section 2001.039, Executive Director staff conducted a rule review of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notice of the review for Chapter 25, published in the January 20th, 2023 issue of the Texas Register, Chapter 20, published in the February 24th Texas Register issue, and Chapters 33, 90, and 116, published in the May 5th, 2023 issue of the Texas Register, with a 30-day comment period. Comments were received on the Chapter 116 rule review from the EPA Region 6, and these comments were reviewed and determined to be outside the statutory and regulatory purpose of the rule review and will be considered when the rule is next substantively changed. Based on the review of these chapters, the Executive Director has determined that the reasons for the rules in Chapters 20, 25, 33, 90, and 116 continue to exist, and changes to the rules identified as part of this review process will be addressed in a separate rulemaking action in accordance with the Texas Administrative Procedure Act. In conclusion, we respectfully recommend approval of the adoption of the rule reviews of Chapters 20, 25, 33, 90, and 116. Additionally, staff request authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project managers and attorneys assigned to these chapters are here with us to answer any questions.
Thank you, Ms. Rico. I have no questions. Colleagues, any questions? Ms. Smith, has anybody signed in to speak?
No one signed in.
All right. Mr. Arthur?
OPIC agrees that the reasons for initially adopting the Chapter 20, 25, 33, and 90 rules continue to exist, and we support readoption of the rules in each chapter. Regarding Chapter 116, it's OPIC's understanding that EPA's comments will be considered as general stakeholder input for possible future policy or rulemaking actions. With that understanding, OPIC agrees that the reasons for initially adopting the Chapter 116 rules continue to exist, and we support readoption of the chapter.
Thank you, Mr. Arthur. Colleagues, what he said, I'm not going to repeat it, but that's what I had in my notes, so I'm ready to move forward with this item.
I have a motion then if we're ready. I would move that we adopt the rule reviews and re-adopt the rules in 30 Texas Administrative Code, Chapters 20, 25, 33, 90, and 116 without amendment as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, let's go back to item 23.
Item 23 is the consideration of the adoption of and hearing on proposed amendments to 30 Texas Administrative Code, Section 50.131C. The Executive Director's staff is here to present this item.
Good morning.
Good morning. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Amy Browning with the Environmental Law Division. With me is Booker Harrison, also with the Environmental Law Division. This adopted rulemaking will reconcile an inconsistency between 30 TAC Section 50.131C1 and the statutory requirements of Texas Health and Safety Code Section 382.061B, which requires Executive Director actions on permits to be reviewable by the Commission. This will amend the exemption for a motion to overturn the ED's decision on registrations for authorization under air quality standard permits. Once the change in the rule is adopted and becomes effective, it would be clear that applicants and affected persons who wish to appeal the Executive Director's decision to issue a registration for a standard permit may request that the Commission overturn that decision through the agency's established motion to overturn process. This administrative action would be required before such decisions could be challenged in district court. Thus, the administrative remedy would have to be exhausted prior to a judicial challenge. The adopted change will allow the agency's rules with Texas Health and Safety Code Section 382.061B, which requires Executive Director decisions to be reviewable by the Commission. The proposed rules were published in the July 14, 2023 issue of the Texas Register. A public hearing was offered on August 1, 2023, and August 15, 2023. The public comment period closed on August 18, 2023. The rule team did receive public comments, and based on those comments, the rule team made the following substantive change. Amending 30 TAC 50.131C1 to state that the exemption to the motion to overturn process applies except when a registration to use a standard permit requires a decision by the Executive Director. This is different than the proposed language, which would have simply deleted the exemption for standard permits completely. In conclusion, staff respectfully recommends adoption of this rulemaking to Chapter 50. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you, and we are available to answer any questions.
Thank you, Ms. Browning. I have none. Colleagues, any questions? Ms. Smith, is anybody signed in to speak?
Nobody has asked to address the commission, but we have at least one individual signed in, Stephanie Bergeron Purdue, who is available to answer questions.
Thank you. What says OPIC?
Hey, yes, thank you. Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. For the record, I'm Sheldon Wayne on behalf of OPIC. Our office has reviewed this rulemaking, and we agree that it is necessary to correct an inconsistency between TCEQ rule and statute. It will provide the public with the statutorily authorized opportunity to appeal the Executive Director's decisions on registrations authorized under an air quality standard permit at the agency level through TCEQ's already existing motion to overturn process. It will also make it clear that such a motion is required to exhaust administrative remedies prior to seeking judicial review. Now, we do recognize that the language recommended for adoption differs from what was originally proposed. However, OPIC understands and accepts the Executive Director's reasoning for the language change. It draws a distinction between registrations under a standard air permit that require a decision by the Executive Director and those that do not. And because it mirrors the relevant statutory language, it appropriately and precisely implements the statute. Therefore, because the purpose of this rulemaking is to harmonize rule and statute, OPIC supports adoption. And I'm certainly available for any questions. Thank you.
Thank you, Mr. Wayne. Colleagues, any questions for Mr. Wayne? All right. Well, as we heard, this rulemaking is intended to make it clear that there is a process for appealing decisions delegated to the Executive Director with respect to air quality standard permits as required by the Texas Clean Air Act, Section 382.061B. And to be abundantly clear, this rulemaking gives persons affected by the Executive Director's decision to approve or deny a concrete batch plant standard permit and similar types of standard permits the right to appeal the decision by filing a motion to overturn under Chapter 50 of our rules. I believe there's unanimity about that objective and that the proposed rule language, which is borrowed from the Texas Clean Air Act, achieves that objective. So I'm ready to move forward with the rule language. I do, however, have some issues with the preamble language and want to clean that up. And this gets us into the distinction between different types of standard permits, and more specifically, which ones involve a decision of the Executive Director that's subject to appeal to the Commission. And I acknowledge that there may be different views on this. Here's my view. And let's start with what an air quality standard permit is. It is a form of pre-authorization issued by the Commission to be available for any person that claims it. Air quality standard permits are established through a notice and comment process under EPA-approved rules to be protective of public health, to be protective of the environment, and to be protective of citizens' procedural rights, as well as to comply with other applicable laws. These authorizations are complete and perfected for individual use when persons claiming them conform to the standard permit requirements. And while some air quality standard permits are effective without notice to the agency, most require registrations. State law singles out some standard permits for additional process, including standard permits for concrete batch plants, permanent rock and concrete crushers, and animal carcass incinerators. These standard permits require public notice, they afford an opportunity for the public to comment, and they require the Executive Director to decide whether to approve or deny the registration. These registrations are akin to case-by-case permit applications, which the Executive Director approves or denies after considering any public comments. My view is that this is the kind of considered decision contemplated by the Section 382.061 right to appeal, and that should be subject to the Chapter 50 motion to overturn process. But I draw a distinction between those application-style registrations and registrations that require no public notice, no opportunity for comment, and no decision by the Executive Director to approve the registration before the authorization takes effect. If a standard permit authorization becomes effective without notice to the agency or without a registration, or immediately upon registration, or when it is accepted or received with no objection, or it becomes effective a certain number of days after the registration is filed, so long as there's no response from the executive director. I don't see that these types of standard permits involve a decision that would be appealable to the commission. I view the public notice and comment and the decision delegated to the executive director to approve or deny the registration as the threshold for motions to overturn approvals of standard permits. And colleagues, I considered slicing this different ways. And I think there are other reasonable ways to approach this, but I landed on this approach because I think it is the best way to provide clarity. I think it provides an appropriate level of process, and it's legally defensible. So again, to recap, I'm good with the rule language. I think we're in unanimity about the objective that we set out to. I just have some edits to the preamble that I might offer into a motion depending on where our discussion takes us. So that's my view of this rulemaking. Commissioner Lindley, how did you come out?
I think I'm okay with that. I agree the rule language should be adopted today. I might take a minute here after I let Commissioner Jamaica speak to talk to General Counsel, but I'll stop there for now.
Okay, and what I would propose after we hear Commissioner Janeka's comments is I can circulate the proposed revisions to the preamble language. We can take a recess and give us time to digest that, consult with our lawyers and so forth. Okay, Commissioner Janeka.
I will offer just a couple thoughts. I'm satisfied with the executive director's recommendation for rule language and the revised response to comments for the Texas Register notice. It mirrors the statutory language which says that decisions that the ED makes on standard permits should be appealable to the commission. I think it's clear that certain authorizations, such as those under the concrete batch plant standard permit, are appealable to the commission. But in looking at all this more closely, there are also some authorizations under the standard permit that don't involve a delegation to the executive director to make any decision. So I don't think our rule should capture those authorizations in the MTO process. I think the rule language and the revised response to comments clarify that there is a subset of non-reviewable authorizations out there, while also making it clear to the public that authorizations like those under the concrete batch plant standard permit have an appeal to the commission.
Thank you, Commissioner. Colleagues, why don't we do this? Why don't we go ahead and I'll ask Ms. Smith to circulate the revisions I'm proposing to the preamble, and then we will take a recess and 10 minutes, 15? Why don't, all right. If you're opening bids 5, I'll say 10.
Start with, okay, that works.
Yeah, okay. So it's 10:23. We are in recess until 10:33. All right, folks, we are back from recess. The time is 10:36 a.m. And colleagues, let me just open it up to you for your thoughts. Commissioner Lindley.
Sure, I'll go first. I don't know. I feel like this one we could go round and round, and probably a lot of people have, because nothing's easy. I think what I like about your preamble language is that, to me, it's clear now. You know, if there's notice and comment involved, then that's something that's appealable, and you've kind of drawn a line with that. And so I think that's defensible, and I think I like that that makes it clear. And so, because of those reasons, I'll, again, I'd support adopting the rule language, because that's, I don't think what we're questioning at this point, but I'd be okay with your proposed changes to, I guess it's the whole RTC, or maybe just the preamble. You're fine with the ED's edits in the RTC?
Preamble that that includes the response to comments. Yeah.
Yeah.
And the edits that you have there are made on top of the edits, the most recent
That we
edits
got.
in the backup.
Yeah.
So that shows both.
Okay,
Yeah.
I'll stop there.
All right. Appreciate that. And just, for clarity, I think the clarity of our position on this was front of mind for me, and as was coming up with a way to articulate this that is legally defensible. Yeah, and also it's not just notice and comment. It's also important, I think, very significant that the commission has delegated to the executive director the decision of approving, or sometimes articulated as granting, but approving or denying the standard permit. So that's kind of my test, but thank you for that.
Policy decisions teed up and focused in this question. And I think that I'm going to keep it very simple and not get into specific types of permits or for which we conduct very similar analysis to those that require public notice and comment. And perhaps somewhere there may even be a little more intensive of an analysis. There could be computer programs that we utilize on what goes into that standard permit. And conceptually, none of that would necessarily disturb the idea that the initial request that had been delegated down through us to the ED through this specific regulatory instrument. I worry, frankly, that this just presents a nowhere else to go dead end for the legislature in order to pull permits up to this level of appeal. They will have no other recourse but to require public notice and comment, and that may be useful. It may, frankly, cost more in terms of our agency's resources to clarify and narrow this window down to say this is the only opportunity where this MTO process, something representing a decision by the executive director, and the underlying statute is pretty simple and any decision by the executive director should be appealable by the public, and that puts us in a very, very difficult dilemma of interpreting what that means on a case-by-case basis. And this one, I think, your option that you've presented to us gives us great clarity in closing off the universe to represent a set of examples that are very clearly executive director decisions. But I would worry that we might be missing some future permitting activities that we would agree on closer scrutiny. That also resembles an executive director decision. I would worry that we're setting the line inside of those. I'm not aware of any particular anything that jumps out as this needs correction, but that's my initial concern.
Yeah, and I understand that, and it's a good point and a fair point. I would say that if either the commission or the legislature thought that there was a standard permit that's not captured by this articulation, given more process, we could easily do that, either through rule or a statute requiring that standard permit to be. But anyway, that's my view. Other thoughts? All right. Well, let me go ahead and move then to executive director, but with the preamble revisions circulated by me today, and that we direct staff to make any non-substantive revisions to the rule necessary to comply with Texas Register requirements. And that is my motion. Is there a second?
A second.
The motion has been made and seconded. All those in favor say aye. Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
Items 29 through 32 are for executive session. The commission will meet in executive session in room 4222, Building F, as permitted by the Open Meetings Act at approximately, say, 11 a.m. Including Texas Government Code Sections 551.0171 and 551.074 to take up and consider matters pursuant to items number 29 through 32 as posted and noticed.
With that, the time is 10:43 and we are in recess.
The commission met in room 4222, Building F, for closed session from 11:01 until 11:46 a.m. on item numbers 29 through 31, as posted and noticed pursuant to the to Texas Government Code Section 551.074. No action was taken. This agenda stands adjourned. The time is 11:56.